Hello, I'm Chris Owen, Head of Commercial Dispute Resolution at TLT.
Hi, I'm Craig Thompson, Commercial Litigator and Partner at TLT.
So this episode of CDR in 10 is on shareholder disputes. And Craig, recently we've been seeing an increase in the number of disputes involving boardroom bust-ups and shareholder disruption. What do you think is driving that?
I think we recognize that shareholder disputes happen in good times as well as bad times. But it's obvious that there's a lot of volatility in the market at the moment. We're going through a bit of a downturn following the pandemic. And shareholders in those circumstances are looking at poor performance, financial distress of their business. There's a pressure on the relationships between the shareholders, and then, of course, that throws up issues of itself. The shareholders often are looking at maybe an exit from the business. They're looking at how the directors are running the business. They're reluctant perhaps to provide further investment in those circumstances, or maybe they're looking at third-party investors and what happens there. There's also maybe disagreements regarding the sale of the business that can bring to the fore issues between the shareholders. And then, of course, there's the sharp end of things where you've got scandal and fraud and issues about remuneration by the directors or dividends paid to the shareholders indeed. So they're probably the main drivers of the increase in shareholder disputes that we've seen in recent times.
Yeah. And Craig, you've just finished a 2-week trial that involved some fairly thorny shareholder issues. And by the time you get to trial, I think it's fair to say that the parties are entrenched, the litigation is very acrimonious. What sort of things can we do and be thinking about to avoid getting to that trial stage?
Yeah, it's rare that a case goes to trial. Certainly in shareholder disputes and unfair prejudice petitions particularly. I think once parties get involved in the formal process of dispute resolution, they realize the high financial and emotional cost which they have to carry. And of course, as well as it being very personal, it takes up an enormous amount of their time and resource. So going back, it's worth spending some time to try and work out at an early stage how you could possibly avoid getting to that point. Prevention is always better than cure. You can work out at the outset perhaps areas of agreement or disagreement. Is there a shareholders agreement itself? Is that something which needs to be adjusted or redrafted in some way? It may not be straightforward, but it may provide a focus for any discussions. Any dispute resolution may then be in the context of the agreement. And then, of course, inevitably, you've got to look at alternative dispute resolution. We're a big fan of that at TLT. And I think probably just pausing on that, you need to think about that as being a process. It's not just a one-stop shop. And often lawyers will look at mediation as being the default. But actually, maybe think about mediation as being the last post. You have to get to a mediation. It's a process. And that is useful because it distills a lot of the issues. So by the time you get there, you've really optimized the opportunity to actually reach a compromise at the mediation. But bear in mind, mediations don't always succeed on the day. They may succeed after the mediation. So understand your rights and obligations. That's important. The parties need to do so because that informs your approach. Inevitably, we're looking at the benchmark of what the court would decide. So we have to look at it in terms of rights and obligations on a legal footing. And litigation, of course, is a last resort. There's no doubt about it. In most cases, parties are trying to avoid getting into court, and the parties' lawyers are trying to fight as hard as they can to try and avoid that. And finally, just one salutary point on that, I think, try to avoid it from a client's perspective becoming too personal. Clients are rightly aggrieved and they're full of animus. They're banging the table, but often that produces more heat than light, it seems to me. And compromise at some stage has to break out. And the parties need to be realistic about that. That's the end result. So how do we get there? And how do we get there most efficiently?
Yeah, no, quite. And as you say, litigation must be a last resort. However, some clients we find are a bit reluctant to mediate, either because they've had a bad experience in mediation that didn't result in a resolution or settlement, or because they see it as another layer of cost. So what other means should we be thinking of to resolve disputes before we get to mediation?
I think really you need to consider what the overall strategy is. work that out at the outset so everybody's clear on precisely what it is you're looking to achieve. You could fire a few shots, of course, without declaring all-out war. You need to perhaps look at any escalation of a dispute resolution process, which is either in an agreement or you could agree one with the other side, absent anything which is in any of the constitutional documents. Are there any technical points which could be dealt with by experts? A particular point which often arises in the context of shareholder disputes is a question of share valuation. Of course, at the end of this process, if it were to go to court, one of the orders which the court often looks to make is a question of whether the majority should be ordered to buy out the minority shareholders. If that's the case, then of course the parties should understand at the outset what value they place on their shareholding. And of course that can give a focus to the parties. And in that context, perhaps it's worth looking at expert determination. Is there something which could be usefully decided by an expert? Share valuation is the obvious example on that. And then, of course, you can also look at something along the lines of early case evaluation, which could mean that you get perhaps senior counsel, a QC, to have a look at the facts of the case and provide at least an opinion that the parties can then evaluate. And it provides them with a means by which they can see the strengths and weaknesses of their case. And then as a broad point, really, I think understand who the real decision makers are. Sometimes when you've got a multi-party dispute, it's not always easy to see exactly who in the shareholder group are the real decision makers and where the authority lies. And is it a dispute which is existential? I mean, really, does it go to the viability of the company? How do you deal with that? I mean, that throws a completely different complexion on matters. And from a lawyer's perspective, I think we're probably duty bound to make sure that the momentum on any settlement is kept going. You keep moving forward. You don't allow matters to stagnate or become entrenched in any way. And parties are all too keen to pull up the sandbags or pull up the drawbridge. And I think probably you should try and avoid that if you can. And as a lawyer, I think you probably should be on the watch for that to ensure that it doesn't happen.
Yeah. So having a very clear settlement strategy is really important. So what red flags or disruptors do you see, Craig, that potentially can derail that settlement process?
I think a client's got to look for the best team, and it's horses for courses oftentimes. They want lawyers who are going to fight their corner, but not take every point. The lawyers have got to have a sense of judgment, and they've got to know that this is a process which they may have to fight to settle. So in an ideal situation, you've got parties working very hard to try and achieve settlement, and they have to come up with a workable solution on that. So you have to, as a client, take responsibility for your legal representation. Who do you want to fight the case, and how do you think it could be best resolved? Often the clients will know the opponents better than anybody else. They'll understand their characters, the personalities involved, and where the pressure points are, and perhaps understand the best means by which they can achieve settlement. Prevention's always better than cure. A lot of disputes could be easily avoided if you had some sort of governance procedure in place. Now, parties may not have considered that when the business was first getting on its feet. And of course, what you need to think about is perhaps fixing the roof when the sun's shining, and maybe looking at the shareholders agreement or the articles and seeing whether they're still suitable, whether they're still fit for purpose. The business may be completely different in terms of its progress and growth from the business which started life many years ago. And has it, in the shareholders agreement, got some sort of dispute resolution process which is clearly mapped out that the parties can rely on when things don't go as well as they want them to? So all of those are the sorts of issues which I think they can usefully consider.
Yeah. So if we just horizon scan for a moment, Craig, what do you see coming next for shareholder disputes?
I think probably inevitably it's more of the same. I'm looking at the macro picture at the moment. In the short to medium term, the economic turbulence that we're facing at the moment can only mean that there's going to be more stress, more tension that's created between shareholders and in the market generally. Increasing inflation and the risk of recession can only bring to the fore underperforming businesses and all of the issues which arise because of that, which I've been through. And also, I think it's probably worth mentioning that third-party funding is becoming more of an issue in the litigation landscape that we're operating within. And I think probably shareholders and class action groups of shareholders will be relying on that more and more in the future.
Yeah. No, absolutely, Craig. Well, look, we've covered a lot of ground on shareholder disputes. So thank you very much for your comments and your insights. And this brings a close to our CDR in 10 on shareholder disputes.